I'm attorney Nick Alcock. I'd like to talk a little bit about what's happening with Andrew Thomas, and he's the former county attorney at Maricopa County, and he is currently facing a disbarment proceeding at the Supreme Court of Arizona. And it's very interesting to see what's happening because really if you know a little bit about criminal procedure and if you know how a county attorney operates, you'll learn a little bit more about really where I think that Mr. Thomas went wrong. And from what I can tell, a lot of what Mr. Thomas is facing relates to the fact that he moved to indict county officials, and he did so by issuing a direct complaint rather than going to the grand jury. And you might wonder, well, what's the difference? Why would it matter how you indict someone? And there are two different ways at the county to seek a felony indictment or to get somebody charged with a felony. One is a prosecutor can basically just tell a judge, here's the evidence, this is what's going on, I'm promising you that this is what the evidence is, and I'm filing a direct complaint. So the prosecutor just unilaterally, on his own or her own, says this is what the evidence is going to be, and so we want to arrest these or have these people arrested. Now, the problem with that is that you, as a prosecutor, are really putting yourself out on a limb. You're saying this is what the evidence is, this is why this person should be charged, without having a more transparent process, without having an intermediary, someone to come in and say, well, you know, maybe there's a question here, or maybe there's a problem with the evidence there. So the other way to go about doing it is to go to the grand jury. Now, the grand jury is composed of just citizens, ordinary people that listen to evidence, and the prosecutor would have to present evidence to the grand jury, kind of like a trial. It's very informal, it's a secret proceeding, and it's done really just very informally. Most hearings last maybe an hour, 2 hours, something like that. After hearing the evidence, then the grand jury can ask the prosecutor some questions, and then they could return a true bill, basically move to have the person be arrested, or they could say, no, there's not enough evidence. And so Mr. Thomas, through his actions, did not go to the grand jury. He didn't have really a hearing where all the evidence was laid out. So this is why this county official should be charged. This is why Judge Donahoe should be charged. And as a consequence, there wasn't that sort of layer of protection for him where he could say, well, look, I presented the evidence to the grand jury and they returned a true bill. And then I took the case to a judge and an indictment was obtained. And as a consequence, it all comes down to the county attorney and the county attorney signing off on direct complaint. And I think that had he gone to the grand jury, first of all, Mr. Thomas probably wouldn't have gotten a true bill, and he would not have been able to arrest the people that he arrested. And basically, he wouldn't be in this mess. And it's something that I've just noticed as a criminal defense attorney here in Arizona, that if you really don't take the time to investigate a case thoroughly, and you move reflexively, have somebody arrested before you have an intermediary look at the evidence, you can wind up with a case that isn't that strong and the case winds up being dismissed. So that's what happened in this case. I think as a consequence, Mr. Thomas is going to pay the price for it. And unfortunately, it just put a lot of question marks as to why it was that he was filing these direct complaints. If you'd like to speak with a criminal defense attorney here in Arizona, you can always give us a call. 602-989-5000 is our number, 602-989-5000, and thanks so much.